All right, good afternoon, everyone. Thanks to everyone who came out today for today's lecture. It's, first of all, on behalf of the Faculty of Law and for the Dean of the Faculty of Law who sends his apologies because he couldn't be here today. It's my pleasure to introduce our guests today. In collaboration with the Faculty of Law, in collaboration with the University of the West Indies Right Advocacy Project, of which I'm a member, we asked, Professor Whitmute, and I know I might not be getting it correctly, has graciously agreed to do this lecture for us today. Just a little bit about the UE Right Advocacy Project. It's a university organization, of which I'm a member, as I said, that we engage in human rights litigation and scholarship within the Caribbean. And part of that human rights litigation are two cases in the Caribbean involving sexual minorities, one in Belize and one in Guyana. Besides that, UE Right Advocacy Project seeks to do scholarship. So here we have reports and academic writings of its members and other persons in relation to human rights and social justice issues within the Caribbean. So this is being one of the parts of our the scholarship aspect of it. Professor here, who is a professor from King's College London, who lectures in discriminatory law, interested in EU law and human rights. He has been a member of many famous litigation in relation to LGBT issues in Europe. And so we are indebtedly grateful to him today for coming and sharing his wisdom. He was, in fact, one of the persons who was on the case in relation to Atala Rifo versus the state of Chile, which is an inter-American court dealing with the issue. So for human rights persons, it will be a great pleasure for us to welcome the professor as he gives us his talk today in relation to LGBT human rights issues and the right to religion. As we would know, the first thing that persons argue when any LGBT rights issues comes up is that we are a Christian nation. We are Christian Caribbean people, that we have these strong moral values, and as such, this is not something that is Caribbean. So Professor would look at that issue in terms of how does LGBT issues and rights square against the right to religion. So it's my pleasure to invite Professor as he gives us his lecture today. Thank you.
Thank you to so many of you for coming out today. It's great to have such a big audience, and this is my first visit to Barbados. Thank you. I've known about Barbados all my life because my parents came on a winter holiday from Calgary, Alberta, Canada in the 1960s. And that inspired me in grade 8. We had to do a report on one Commonwealth country of our choice, and I did my report on Barbados. But it's taken me, I think that report was written in 1970. So 44 years later, almost, I finally get to visit the country. I've prepared a handout, which I hope will be distributed now. I don't know if we have enough copies, but you'll see that it's divided into two parts, basically law and religion. And this morning, I think when I was in the shower, at some point, I decided I was missing a part. People, the human part, the social reality. So this part is not on the handout. So I'll talk about that first, and by the time I finish, the handout should reach you, and then we can move on to the law and religion. Okay, so the people part, the human part, the social reality is that in every country everywhere in the world, there is a small minority of men who are sexually attracted to men, who fall in love with men, who ideally would like to have a primary relationship with another man, and women who are sexually attracted to women, who fall in love with women, who would like to have a primary relationship with a woman. That is a social fact everywhere, including in Barbados. And nobody knows exactly how big this minority is, but I would say you could take that it's at least 2% of the population. Now, I'm willing to volunteer to represent this minority today, and I'm going to talk about my life as a gay man. I was born in 1957 into a world of complete criminalization, almost complete, I don't know of many exceptions, across the entire English-speaking world. July 1957, sexual activity, at least between men, and in some cases also between women, was illegal in all 50 states in the US, in Canada, across the English-speaking Caribbean, in Britain, Ireland, Australia, New Zealand, etc., almost every part of the former British Empire, with no exceptions whatsoever. In September 1957, the second sign of change came. The first was 1955, the American Law Institute published a model penal code which recommended that private, consensual, adult sexual activity should be decriminalized. That was the first reform proposal, which was very influential in the US. In England, the equivalent was the Wolfenden Committee report, September 1957. So I was less than 2 months old when it was published. So in a public lecture in London, I described myself as a Wolfenden baby. Yes, let's move on to the 1960s. And 1968, Pierre Trudeau is elected Prime Minister of Canada. He had been Justice Minister. At some point, he had said, the state has no business in the bedrooms of the nation. And in 1969, around the time of my 12th birthday, Canada decriminalized. England and Wales in 1967, Canada in 1969. Now, there's, I think it could be said that decriminalization is quite a minor concession because it doesn't actually make you feel immediately welcome, included, accepted in your society. So I grew up in post-decriminalization Canada as a teenager, aged 12 to 17 or so, really hating myself. I would see the word homosexual in print, and it would send a chill down my spine. I just thought, that is a fate worse than death, and that's something I will never be. I knew I was attracted to other boys, but I just had to fight it somehow. I said, the options I saw for myself, one would be that I would become a monk, join a religious order, so I would have a good excuse. And the other, I thought, well, after I finish my undergraduate studies, I'll get a job and I'll be able to pay for a psychiatrist who will cure me. So those were my plans back in, around the time of my Barbados report, not long after. Fortunately, things got better. I had a long series from the age of 16 to 21 of crushes on my male best friend I was madly in love with, couldn't say a word about it. And finally, I came out to one of those male best friends when I was a first-year law student at McGill University in 1979, and he was very supportive, gave me some ideas as to who else might be gay in our first-year class. And so one of the guys, I thought, yeah, I think you could be right. So I approached him at a dance, and anyways, he was my introduction to the gay community and eventually took me out to bars, and I was much, much happier after that. So that's just one person's story. But I would say the real issue we have here is a question of a new form of human diversity, one that is not really recognized in most countries in the world, and is largely invisible. And the struggle is to have this difference become more visible and more accepted. The reaction of most societies in the world has been to fear it, to see it as a threat, to call people who are same-sex attracted criminals, sinners, mentally ill people, etc. And fortunately, that is gradually changing in more and more countries, and the trend is to accept and respect that we have a new minority we didn't realize was there, and they have the right to be, eventually treated equally. So my conclusion here is that lesbian and gay people are in Barbados, they're here to stay, they're not going away. And they're not different to annoy the majority or to offend religious people. It's just what they are. So they're not going to change. What needs to change really is the majority's attitude towards them. They just want to be themselves. Okay, well that's the personal part. Now, most people should have a handout in front of them. Yeah? I always like to have a handout so you have some kind of souvenir. It's kind of like the program, taking it away from the lecture. Okay, if we look at the law, especially international and comparative law, above and beyond Caribbean law, there is a solid international consensus that same-sex sexual activity should not be criminalized, that this is a violation, at least, of the human right to respect for your private life or your privacy. Now, this is a fairly recently developed consensus, because as I mentioned, it certainly didn't exist in 1957 when I was born. But if we look at the Council of Europe, which is an international organization like the Organization of American States, it's bigger than the European Union. The European Union has 28 member states. The Council of Europe has 47 member states. It includes Turkey and Russia, for example. And just the other day, it was announced that in northern Cyprus, which is occupied by Turkey as a government that's not recognized by most countries, where the British criminal law was still in force. It was the last little pocket of Europe where there was criminalization, and the parliament there has just voted to repeal it. So we could say it's a bit like getting rid of, is it smallpox that we got rid of and only exists in a test tube or vial in a lab somewhere? So this human rights violation is now over in Europe in terms of criminal laws, although it doesn't mean there aren't people who would like to see it come back. And some members of the Russian Orthodox Church have been calling for recriminalization in Russia, which is related to the propaganda law you may have heard about, which has led to a lot of protests relating to the Sochi Olympics, which started last night, was it? The opening ceremony? Yeah. Okay, so in the 47 Council of Europe countries, these laws are gone. If we look at the 35 member states of the Organization of American States, these laws are gone from 24 out of 35. So if we add up these two international organizations, we have 82 member states, 71 have decriminalized. Where are the exceptions? All in the Caribbean. It seems to be a kind of Caribbean exception. 11 of the 12 independent countries of the English-speaking Caribbean, all except the Bahamas, which decriminalized in 1991. Has the social order collapsed in the Bahamas? Has anyone noticed? Anyone been there recently? No. Okay. That's good to hear. There's also a group of British overseas territories that were decriminalized from above by order from the United Kingdom. And you see, I think of that list, I think only Bermuda had already done it voluntarily. But Anguilla, British Virgin Islands, Cayman Islands, Montserrat, Turks and Caicos all have decriminalized through an order from London. I have a paper copy of the order, and I couldn't find it in my office, and I couldn't find it on the internet, but this definitely happened at least 5 or more years ago. Why? Because the European Convention on Human Rights has been extended by the United Kingdom to all of its overseas territories. So anyone a gay man in Cayman Islands could have taken a case against the United Kingdom in the European Court of Human Rights. So to stop that from happening, the law was changed. Okay, that's a quick overview of legislation. Now, what do international human rights tribunals have to say about this? Well, there was no case law until 1981 when Geoffrey Dudgeon brought a case against the United Kingdom dealing with the legislation in Northern Ireland. Now, England and Wales decriminalized through an act of Parliament in 1967. Scotland did the same in 1980. But Northern Ireland, you could say, was the Caribbean of the United Kingdom. I must say I haven't noticed it in terms of beaches or climate, but in terms of let's say, Christian exception, different moral values, etc., no, this was not going to happen in Northern Ireland. In fact, the campaign slogan was "Save Ulster from Sodomy," Ulster being another name for Northern Ireland. So Geoffrey Dudgeon took his case to the European Court of Human Rights, and he won in 1981. This is the first international decision on this question, and it's now cited around the world. The court decided, first of all, that sexual life is part of private life. It took them about 5 words to decide that. In the US, hundreds of law journal articles had been written on it, and the idea was rejected by the US Supreme Court the first time around in Bowers versus Hardwick, but they thought that was obvious. So the government had to come up with a strong justification. They said particularly serious reasons for interfering with the most intimate aspect of private life. And the government just didn't have any. An influential factor was that most countries in Europe had decriminalized. Now that is the way the European Court of Human Rights interprets the Convention. If the numbers had been different, like in the Caribbean, the decision would have gone the other way. They would have said, there is no consensus as to how to deal with this issue, states have a wide margin of appreciation, etc. But in fact, at the time, the score was basically 17-3. So you had 17 countries with no criminal law. The 3 that did were the UK for Northern Ireland, the Republic of Ireland, and Cyprus. So that didn't deter the court, the state of legislation. And another argument of or another factor that counted against the United Kingdom was the fact that the law wasn't being enforced. So the test they had to satisfy under Article 8, Paragraph 2 of the European Convention on Human Rights, they had to show why it was necessary in a democratic society to criminalize private, adult, consensual sexual activity. And if they go into court and say, well, actually, we don't enforce the law, it doesn't sound like much of a social problem. So keeping the law on the books merely to stigmatize and condemn a minority is not seen as a justification for it. So the court found a violation of the convention in that case, and the UK changed the law in Northern Ireland in 1982, the following year. Subsequent cases were brought against the laws in Ireland and Cyprus. Same judgment from the court. The law was changed. And then in the 1990s, as countries in formerly communist Europe were joining the Council of Europe, they all changed their laws. So these gradually disappeared. Now, what about the United Nations level? Well, a similar case went Nicholas Toonen from Tasmania in Australia took a case to the UN Human Rights Committee. Very similar reasoning under the International Covenant on Civil and Political Rights. About the only difference was that the Dudgeon case was decided in 1981. Technically, you could say that the phenomenon of AIDS was first announced in June, July 1981, but certainly it wasn't. It hadn't really been properly identified, and they didn't know the cause, they hadn't identified the virus, etc. So public health was not argued in the Dudgeon case. It was by the Tasmanian government in the Toonen case. They said we need to maintain these laws in force to prevent transmission of HIV. And the Australian government made the opposite argument, said no, these laws are counterproductive, they're harmful. And I think this is the general consensus amongst public health workers around the world. If you're trying to protect people's health, you don't make them criminals. Because you want them to be open about their sexual activity, to be able to speak about it freely when they're talking to a doctor, a nurse, anyone working on health issues. And if they're admitting to a criminal offense, that is not going to promote disclosure and education about how they can protect their health. So that argument was rejected by the UN Human Rights Committee back in 1994. Now, there was a subsequent case, X versus Colombia, which was dealing with unmarried same-sex partners. And the two members of the committee from Egypt and Tunisia dissent. They didn't agree with that there had been discrimination in the case, but they confirmed that they agreed with Toonen. No doubt that these criminal laws violate the International Covenant. Okay, over the top of page 2 and to the Americas. Now, Barbados is a party to the American Convention on Human Rights, in which Article 11 gives everyone a right. It says no one may be the object of interference with his private life. To date, there is no case law from the Inter-American Court on this issue, but if you read the court's judgment in the Karen Atala versus Chile case, in which I was an expert witness for Karen Atala. Actually, that was the last time I came near Barbados, was August 2011, flying from Frankfurt to Bogota, where the hearing was held. And I noticed on the map, but I couldn't get them to stop. So that judgment is found that there was discrimination and violations of various rights in the American Convention, because Karen Atala was a lesbian mother, actually a trial court judge in Chile. She married a man. They had 3 children, 3 daughters. She realized she was lesbian. They decided to separate. They had an agreement that she would have custody of the 3 daughters. And then she met a woman and fell in love. And the woman moved in with her. And her husband couldn't stand that idea. He didn't want his children growing up with this perversion in front of them. So he went to court. He lost at the trial level. He lost in the Court of Appeal. And he won by 3-2 in the Supreme Court of Chile. And so in May 2003, she lost custody of her daughters and only had visitation rights. So she was a fighter, and she went on to the Inter-American Court, and she won. But the language, if you look at the reasoning, it is so strong, there isn't the slightest doubt that the Inter-American Court would decide that a criminal law banning private, consensual, adult, same-sex sexual activity is contrary to the American Convention on Human Rights. There is a case pending against Jamaica in the Inter-American Commission, the AIDS-Free World case, and I have no doubt that that will be successful. The only problem is that the case is successful in terms of generating an opinion from the Commission that Jamaica is violating the American Convention. But my understanding is that opinions of the Commission are not legally binding. The case would have to be referred on to the Inter-American Court, and Jamaica does not accept the jurisdiction of the Inter-American Court. So that would be the end of the case. But there is one country in the Caribbean that has a criminal law and does accept the jurisdiction of the Inter-American Court of Human Rights, and that is Barbados. So I think it would be a good idea to have a case against Barbados. So we need to find someone who's willing to take the case with the guarantee of anonymity. So basically, I'm willing to be their lawyer. So just Google me, look for my email address, and we could get this going maybe. So yeah, I have no doubt it would be an easy case. X versus Barbados would sail through the system, clear violation. So, but I hope that won't be necessary because the law will be changed before then. But in any case, it's always good for publicizing an issue and putting a little pressure on the members of Parliament. Okay, well that's a survey at the international level. What have national courts had to say? Well, there are a lot of decisions of U.S. state Supreme Court saying that criminal laws of this kind violated the state constitution, and the first one is way back in 1974 in Massachusetts. The issue never went to the Supreme Court of Canada because of the Parliament had decriminalized in 1969 before the Canadian Charter of Rights, which came in 1982. But there were two cases dealing with the age of consent to anal intercourse, which is 18 in Canada. At the time, it was 14 for all other sexual activity. And the Ontario and Quebec Courts of Appeal both struck down that higher age of consent as discriminatory. And in the Ontario case, they definitely rejected the public health argument as well. Lawrence and Garner versus Texas, 2003, the U.S. Supreme Court found a violation of the right of privacy. There were still about 13 states in the U.S. that had not decriminalized, including Florida. So same-sex sexual activity was illegal in Florida until 2003 when the law was struck down. Now, some people would look at these decisions, let's see, well, Australia, Northern Ireland, Massachusetts, Quebec, etc., Texas. This is all sort of affluent, white, northern parts of the world. This has nothing to do with the global south. Well, the following list of cases is from courts from the global south or the non-European world, however you'd like to describe it. Ecuador, South Africa, Fiji, Hong Kong, Nepal. It's quite an impressive group. And then you had the Delhi High Court judgment. And things were rolling along very well until we hit a bump in the road on the 11th of December when two judges of the Supreme Court of India overruled the Delhi High Court. The Delhi High Court in 2009 read down Section 377 of the Indian Penal Code, which was introduced by Britain in 1860, which criminalizes what would be called buggery in Barbados, anal intercourse. Carnal intercourse against the order of nature is the offense in India. And the Delhi High Court looked at lots of comparative law. They cited Dudgeon, Tunin, Lawrence versus Texas, all these cases, produced a very eloquent judgment, talked about the inclusiveness of the Indian Constitution. They talked about a concept of constitutional morality. So it wasn't enough to argue morality, you had to argue a morality that was consistent with the Constitution. And they found it would be contrary to the Indian Constitution to apply this law to private, adult, consensual, same-sex sexual activity. Two judges of the Supreme Court overruled their decision on the 11th of December in a judgment I would consider an embarrassment for the Supreme Court of India. it was a case of really shutting their eyes. They just did not cite Dudgeon, Toon, and Lawrence, anything. They ignored everything, all legal developments outside of India, and used some fairly offensive language referring to lesbians and gays in India as a minuscule part of the population. Well, if they're 2%, that's similar to the percentage of Sikhs or Christians in India who have rights under the Indian Constitution. They do have a pattern of looking to legal developments elsewhere in interpreting the Indian Constitution, but in this particular case, departed from that. There is an application now to seek review by 5 judges, so there is still the possibility that it will be overturned, and that will be a very significant judgment for the Commonwealth if and when it comes. You note the study at the bottom of page 2 on the higher prevalence of HIV in Commonwealth countries. So a disproportionate percentage of the people with HIV in the world are in Commonwealth countries, and 80% of Commonwealth countries criminalize same-sex sexual activity. So that is another example of how public health officials argue that the criminal law should be changed. And in fact, that was one of the main arguments in the Supreme Court of India, Delhi High Court and Supreme Court, was that this law was interfering with HIV and education in India. Okay, page 3. Would decriminalization restrict religious freedom? I understand that this is a common argument that's being made in the Caribbean now. There are 2 ways in which I address it. The first is to argue for a complete separation of law and religion. Religion, to me, is something that should be entirely personal. It's a set of rules that you believe in and that you follow that guide your own life, but you never ask the state, through the vehicle of law, to impose those rules on other people. Religion should always be voluntary. In fact, for me, religious law is a contradiction in terms. Because if it's religious, it should be voluntary. It's, to the extent that it's law, it's enforced within the community. It might affect your membership of the religious community, but it's not law in the sense that you might go to jail because of it. I found a nice quotation from Gandhi supporting this idea of the religion is personal. There's also a famous verse from the Quran, there shall be no compulsion in religion. Let's examine this idea that whatever the Bible says should appear in the criminal law of Caribbean countries. Well, I just taken at bottom, the second half of page 3 is just an extract from an article I published in an Indian law review. And so I started with Leviticus chapter 20, verse 13. If a man also lie with mankind, he's committed an abomination, they shall surely be put to death. Okay, well, at least it's good news that the Caribbean hasn't implemented that part of the Bible. But if you look through Leviticus, it says they shall, I just did a search in an electronic version of the text for they shall surely be put to death. And it says cursing one's parents. Okay, I don't think even in the Caribbean anyone would call for that. Committing adultery, sex with an animal, being a wizard. That's what it says in Leviticus. If you're a wizard, you shall be put to death. And in particular, blasphemy. He that blasphemeth the name of the Lord, he shall surely be put to death, and all the congregation shall certainly stone him. Okay, I don't think there are many stonings every Sunday in Barbados or any other Caribbean country. So anyone who argues that this criminal law must be maintained to respect their Christian religious beliefs is reading the Old Testament in a very selective way and ignoring many other provisions that we consider outdated. So the last paragraph is basically my own analysis of historically how this provision got into this prohibition got into Leviticus. As I said, reflecting the human rights standards and scientific knowledge of the time. If a society at that time, if you saw two men making love, you might be horrified. First of all, you have a strict gender hierarchy. Men are superior to women. So here you have a man who appears to be acting like a woman. He is basically a traitor to the male gender. He's forfeiting his superior status, so we've got to prohibit this. And then you have societies where people are concerned about population. We've got to have lots of babies. We're competing with the tribe on the other side of the river. We've got to have soldiers for battle. And, these two guys are wasting their sperm in a non-productive way. We've got to stop this. Okay? Well, if that's the original rationale for this prohibition, it really has no relevance to the 21st century, where we belatedly decided that men and women are equal and can do whatever they want, and where underpopulation is not the problem on our planet. Okay, so that's my first point, that law and religion are separate. If you're Christian and you have strong beliefs that sexual activity is a sin, that same-sex sexual activity is a sin, anyone engaging in it will be punished, will burn in hell for eternity, that's fine. You can hold your belief. Just let other people get on with their lives and don't ask the law to intervene. You can tell your children it's wrong until they are adults and leave home, and they can think what they like. You can, if you want, stand on a street corner and preach, although we'll come to that in a second. But yeah, you can hold your belief, but don't impose it on other people. That's what I would say. So the next point is the question of the slippery slope. And this is I heard of a Christian lawyer from London who flew to Jamaica to attend a conference in December and was telling people there, don't even think about changing your criminal law. It's the beginning of the end. The end result will be that you'll find Christians are persecuted by the lesbians and gays who take over and control everything. This is essentially the argument. But translating it into legal reforms, and now being serious for a moment, the big problem in the world is we have countries at every single stage of legal reform. We have a small group of countries with 100% equal rights. Same-sex couples can marry and adopt children jointly. We have at least 75 countries with criminal laws. We have a few, at least 5, with the death penalty. This is all happening at the same time. The way I look on it, it's sort of like imagine a lesbian and gay pride parade that has a route like a horseshoe. So it goes out this way, it comes back, and it finishes here. So the people at the start of the parade can see the end of the parade. And some of them are saying, no, we don't want to move. We're going to stay at square one because we don't want to end up there. And this is a big problem for lesbians, gays in the Caribbean, in Africa, in many parts of Asia, which we didn't have to face in Europe, Canada, the US. In those countries, people could go propose one reform at a time, and no one would ever say, but if you get that, then it will inevitably lead to X, Y, Z. People were arguing for decriminalization in the US Supreme Court in 1986. No one said, well, this will lead to marriage. Why not? Because in no country anywhere in the world could a same-sex couple register their relationship in 1986. That didn't start until Denmark in 1989. And marriage not until 2000. The law was adopted in 2000 in the Netherlands. So, but now that all these changes have taken place, people are aware of them all over the world. So you have a country like Singapore where they have a criminal law. They refuse to change it because they say, well, we'll be pressured to introduce same-sex marriage. So we're just going to leave things where they are. Meanwhile, they promote lesbian and gay tourism to Singapore, so quite hypocritical, I would say. So is it true that you decriminalize and within 2, 3, 5 years you have to allow same-sex couples to marry? I would say no. I mean, we have one example, which is the Bahamas, 22 years and counting, no sign of same-sex marriage there. The way I sum it up is to say each country can consider reforms to its laws at its own pace. Each country at its own pace. And the pace can be very slow and leisurely. So England and Wales, decriminalization 1967. When was the next act of Parliament introducing equality? 2000, 33 years. The pace picked up then, and the anti-discrimination legislation, civil partnership, joint adoption, etc. followed. Finally, a prohibition of incitement to hatred based on sexual orientation. And a similar timeline in Canada, 1969 for the decriminalization. Now, and I'll just wind up now because I want to allow time for some questions. One argument that is being made by this Christian lawyer flying into the Caribbean from London, saying, if you quote the Bible, it'll be hate speech, and you'll be the criminal. So the world will be turned around. Instead of sending the lesbians and gays to prison, it'll be the God-fearing Christians who, quoting Leviticus, will be charged with inciting hatred based on sexual orientation and will be sent to jail. Well, there was a controversial case of a preacher in the street in Britain who was charged with a public order offense. But on the whole, prosecutions of religious persons under these laws almost never succeed. Generally, freedom of religion is used as a defense successfully. Certainly there were cases in the Netherlands and Sweden where the courts did not convict. And in both England and Wales and in Canada, there are specific provisions that provide protection. The one in the Public Order Act, Section 29J, specifically excludes criticism of sexual conduct or practices or urging of persons to refrain from them. And the Canadian Criminal Code specifically exempts establishing by an argument an opinion on a religious subject or an opinion based on a belief in a religious text. Okay, so I would say that this is scaremongering, what people from Britain are saying. I think it's time for Barbados to decriminalize. And if Barbados takes another 20 to 30 years to think about the next step, that's up to Barbados. But the first step is long overdue. And I think it would be something Barbados could be very proud of, to be the second country in the Caribbean to change the law and show the way for Trinidad and Jamaica. Thank you.
Thank you very much, Professor. So I said you indicated several things. One, that using the religious argument as a defense to decriminalization or any of these actions is really one of evangelism by criminal law. And it is forcing persons to, in fact, have a particular Christian religious view. And the right to religion, as you know, is not only the right to have a particular religion, and in more jurisdictions in the Caribbean there are different types of religion, but it's also the freedom not to have one or to hold that particular view. And to actually force someone to hold that particular view, as you were citing, is actually breaching that same fundamental oath that you're entitled to have that particular religious view. Christians themselves were the main persons who that was used against. All right? And so for Christians to turn around and want to do it to others It's quite interesting. And I've always told my students in the class, I think the Caribbean itself, the ones who have, we ourselves, who have been subject to so much prejudice and discrimination, and who more than anyone knows what it is like to be not considered an individual, but rather property, would turn around and do that to another set of person. It's quite hypocritical, and is not actually, that is, I think, not Caribbean. But the other part is that it does not necessarily mean the other. And you're right, in the European Court of Human Rights, they did not find that same-sex marriage was one that was recognized in Europe at that point. And that's partly because it was no consensus, as you indicated. And as well, in all of it, when we talk about gay rights and so on, we forget about the women. And lesbians are a major part of these types of actions as well. And it also connects with our concepts of masculinity in the Caribbean, and that men are to be dominated, as you said, women. And I think women more than anybody would say, I agree that you shouldn't be discriminated against, because that is also inherently discriminating against us as well. Just a couple of things, I think, in relation to the Caribbean. I think there are Caribbean judges who have, in fact, in the Court of Appeal in Trinidad and Tobago, the now Chief Justice and then a Court of Appeal looked at the issue and thought it was discriminatory. It was, however, overturned by the Privy Council, not actually dealing with the issue. So there are the aspects, but as the professor says, there are some constraints in the Constitution in the Caribbean, including a general savings law clause and so on. All right, but I thank you very much to everyone. I think Mr. Davies, who is president of the Law Society, would just like to say a thanks and give a vote of thanks, and then we all can go to our regular daily schedules.
Good afternoon, Law family, and the members of other faculties. I see some members of academic board here, so good afternoon to you too. Today's lecture was a truly magnificent one to be had, and it comes at a critical point in relation to the development of our region and regional jurisprudence, and the increase of regional efforts to end discrimination of all kinds, which this university helps lead with its rights advocacy group. A possible end to discrimination means an increase in HIV awareness, among other things, and an increase in perhaps what we call marriage tourism in the Caribbean. And you know, these days we have to scratch for every penny that we can possibly get. So that perhaps would be a more persuasive reason for Parliament to end discrimination. But anyways, on behalf of the Faculty of Law, I would like to thank Professor Wintermute of King's College for adding to these efforts and leaving us with a wealth of knowledge on discrimination issues. I'd also like to thank you all for coming out, for it shows that you all have, well, most of us are committed to the fight against discrimination. Thank you.